Welcome to the Two Gurus Talk Compliance podcast with me, Kristy. I'm here with the one and only Tom Fox, and this week we're covering what compliance needs to do about the alleged movement of forced labor out of the Uyghur region into other parts of China, whether Europe is over-regulating itself into irrelevance, the exponential growth of data subject access requests and the cost associated with them, and why employees allegedly don't want cash bonuses. Hey, but first, Tom, how's your week been, and what do you think has been the most interesting development?
I have to say, today's testimony at the Trump trial of
Uh,
Stormy Daniels took the U.S. presidency to perhaps the lowest point since Watergate, maybe even beyond. The testimony of Daniels, it wasn't gut wrenching. It's not things that should be shared in a court of law involving the president of the United States, period. And I was just so disheartened by all of that. That was it for me so far.
so that is an interesting development. So there is, oh my goodness. But we also have people in New York, other people in New York courts, Tom. Which one do you want to talk about?
I wanted to start with a story I came across from Reuters on an ex-McKinsey partner who says is being scapegoated by McKinsey for its work on the opioid crisis that is being investigated by the U.S. Department of Justice. So McKinsey's had lots of footprints around some really dicey stuff over the years. They were around the state capture in South Africa. They've been around some work from some other rulers in other African countries. And they were assigned, or took the assignment rather, to help the Sackler family and Purdue Pharma ramp up opioid sales around OxyContin. And now they're under investigation for their role in that. They have paid $1 billion for their involvement in this. And now one of the partners, former partners, I should say, who's involved in this, who was terminated, claims he's being scapegoated by the firm. And part of it is interesting because he's accused of not shredding documents, but deleting documents. And the firm is clearly pointing to him as the bad apple. There's going to be more, even if it's a bad apple, it's going to rotten out some of the fruit. And I got to believe there were other bad apples. Interestingly, Goldman Sachs ended their DPA around 1MDB literally this week. So perhaps that's a bookend to talk about, and it shows that corporations can work through these issues, even if they engage in corporate behavior that is less than ideal or even violative of the law. But whenever you have a partner who's involved in scandalous activity, saying he's been made a scapegoat for the company, the firm, the whatever, pay attention.
So, Tom, when I first read this, I thought, why is this in the news right now? Because the opioid scandals have been open and shut for some time, right? With the amounts paid. But then the reason, looking closer, was because literally the man filed 2 days after it came out that the DOJ was doing an investigation. Why do you think that they're still looking at or suddenly in the middle of this after these settlements have already occurred?
Well, settlements are on the civil side, and the
Mm.
DOJ investigation is a criminal investigation. Clearly, was no waiver or waiving of rights during criminal charges, as you would expect. And the allegations of document destruction, I think, are something the DOJ takes very seriously. And if it turns out somebody was lying, hiding, and storing documents, I think that DOJ may go after that, whether it's a corporation or whether it's the individuals who engaged in the conduct.
Yeah, it'll be interesting. Watch this space. I'm sure it's going to take some time to get through this one, but one more gift that may keep giving as these litigations go through.
So you were brought us yet another issue, or article, I should say, about forced labor. And I also read this article, and I don't know if I would call it disturbing. I would call it interesting, or something that we need to actually do a client alert on, because this is something every compliance function needs to be aware of.
Yeah, I think that this one is absolutely critical. And it's not just because I have a very strong feeling and sense of morality, and we do so much work around human trafficking and trying to be in compliance with these laws, but the article comes from the Wall Street Journal, and it has potentially massive implications for compliance officers. So it's titled, China Moving Forced Laborers Amid U.S. Crackdown, Biden Official Says. So the story follows a hearing before the bipartisan Congressional Executive Commission on China, which we hear about a lot, where Deputy Undersecretary for International Affairs at the U.S. Labor Department, that's a big title, said that China is increasingly transferring the Uyghur forced laborers and other minorities to work elsewhere in the country, especially in the seafood industry, which is pretty notorious. This movement is, at least in part, a strategy to evade US laws prohibiting certain goods from the Xinjiang region from coming into the US unless a company can rebut the presumption that the goods were made with forced labor. Now, this is obviously worrying for compliance officers on a number of levels. So it may soon be that many more categories of goods or regions sourced from China may be engulfed in this law. Normally, we would advise that on the ground audits are the best way to respond to this risk. Certainly, that's the way we would recommend responding. But the deputy undersecretary is not convinced. He said social audits in China should not be seen as an authoritative source for companies reflecting on the ground's human rights conditions. The business community needs to be aware that any audit and, frankly, any business operations undertaken in China carry heightened labor and human rights risks, unquote. The language actually ratcheted up from there. The chair of the congressional committee told compliance departments, lawyers, and accounting firms that sign off on public disclosures specifically that he was personally asking the SEC to take action against public companies that release, quote, misleading public disclosures, unquote, about forced labor. Okay, Tom, I see this one escalating significantly. That congressional committee is bipartisan and not messing around. If the SEC gets involved, obviously that's a big deal. And for you faithful listeners, you probably heard that we were bid several weeks ago that the committee called on the Department of Justice to look for corporate prosecutions around this risk area as well. So obviously, this is a politically fraught issue. China says that they're doing no such thing as forced labor with people in the Uyghurs. However, this obviously is a big deal for compliance. What do you think happens? Do you think that this is time for prosecutorial engagement, or is it too politically fraught?
I think you're spot on that we're going to see nothing but escalation here.
Yeah.
If China is going to pull this in, run around the law, well, guess what? They're going to expand the law and they're going to expand it to all of China. And that is going to put a significant, and I mean significant burden on U.S. companies. It is going to significantly restrict and negatively impact trade. And this will, I understand China's response, but I certainly understand the way the U.S. is going. You're also spot on that this is, for reasons we can only thank, a truly bipartisan issue. And if U.S. senators want to get behind, or senators, U.S. representatives and senators want to get behind something on a bipartisan basis, this really has no one on the other side to argue against it, except maybe Rand Paul. And I think it's just going to get worse and harder, and the law is going to get more expansive and more expansive. And it's in the interest of the U.S. to prosecute those who violate this law intentionally or unintentionally. So I think we'll see more prosecution. I don't think the DOJ will step off the accelerator if the law expands at all. And I think every export control officer in every country doing business directly or indirectly with China needs to start preparing to be able to affirmatively show the goods or services were not obtained with forced labor, no matter where it came from in China.
I think that if you're a compliance officer, you should start sounding the alarm that we need to talk about supply chain redundancy and trying to figure out where else you can source from, because this could be a very big problem very quickly. And this really is one to ring the alarm at the board level.
Absolutely. Over to AI.
AI.
As reported by the Wall Street Journal, Risk and Compliance Journal, Mingy Sun telling us that the CFTC, the Commodities Futures Trading Commission, has promoted Ted Kauk to its Chief Data and Artificial Intelligence Officer role. So we have a Chief Artificial Intelligence Officer at the CFTC. I think this portends a big change across almost every government commission and agency. I think we'll see a similar role. I think the DOJ is certainly moving in that direction. I think this person will have an inward assignment or inward look that will respond to the Biden administration's push to govern the use of AI across the federal government, but also it will be an outward look as well, because this person could be a subject matter resource for enforcement actions over more powerful AI systems that come into place. So I think it is something expected, Christy. I think the government, the Biden administration, the Department of Justice, the SEC, and now the CFTC have made clear that this is something that is important to them and that they will be taking a very close look at, as clearly evidenced by the appointment of the first chief artificial intelligence officer at the CFTC.
Yeah, I mean, the thing that caught my eye really in this article was about the Biden administration, as it is publicly committed to hiring 100 AI professionals by summer to promote safe use of this technology with the government. And I think we talked about this in December, Tom, about whether they're going to be chief AI officers. So this, like, what's our IO or CDAO? If it's the chief data artificial intelligence officer, I'm looking for the time when the new acronym sticks.
Or can go to the other direction and say, how can you tell if someone's an AI subject matter expert? They can spell AI.
It does kind of feel that way right now that everyone is an AI expert because they can spell it.
It's like GPDR was. If you could spell GPDR, you were a GPDR expert.
Or even GDPR, same idea.
That too.
Somebody recently said to me they're trying to get training in, and they said, my board can't spell FCPA. So I thought, okay, there we go. All right, let's move over to some other folks who are in technology and not getting it right. This is Robinhood. This is the first of two articles this week relating to crypto, our favorite subject. Crypto is for crime. But this one is from Reuters, and it's entitled Robinhood Crypto Gets Notice from the U.S. SEC, as in Securities and Exchange Commission. The retail stock, bond, and crypto trading platform said it has received an enforcement action notice from the SEC regarding its crypto tokens specifically that are traded on the platform. So the communication, which is known as a Wells notice, does not necessarily mean the company has engaged in wrongdoing. However, it does mean the company will be in a world of hurt because the SEC is planning to bring this enforcement action against them. Robinhood's defense should surprise no one who is either paying attention or listening to us. According to Dan Gallagher, Robinhood's chief legal, chief compliance, and corporate affairs officer, quote, we firmly believe that the assets listed on our platform are not securities, unquote. Now, Tom, seriously, this guy has 3 C-suite jobs. He is the chief legal, chief compliance officer, and also corporate affairs officer. This seems like a lot for one person. Anyway, back to the story. Robinhood has been trying to get registered with the SCCE for 2 years now. It hasn't happened yet. Not sure how that's going to go at this point. So, okay, the SEC has been fighting battles of whether crypto should be regulated by the commission or not. Obviously, people argue both sides of this. I believe you're on the yes. It is a regulatable thing by the SEC. What do you think? Does this change anything? In this investigation?
Yes, I do think it's a securities, and I think it should be regulated. And I think Robinhood's been playing fast and loose with this. It does not surprise me at all. You work very hard, Kristy, but I'm not sure even you would work hard enough to be the chief legal officer, chief compliance officer, chief corporate affairs officer of a multi-billion-dollar crypto company. So
Honestly, I saw that whole string of titles and I thought maybe that's why he's got too much to do to realize that this is the position that
he just might.
I mean, but we see what happens when crypto goes bad. What happens when crypto goes bad, Tom?
A lot of people lose their money, and then there's an enforcement action and a big fine against a company that doesn't have any money.
And then somebody might go to jail. What happened there?
Somebody might go to jail, and the CZ, Changpao Zhao, the founder of Binance's largest shareholder, former CEO, was sentenced to 4 months in prison. Yes, 4 months for having one of the world's biggest money laundering operations going on. And I'd like to spend some time around this, Kristy, because I thought this was significant, obviously, for CZ and Binance, but I thought it had a lot broader implications and some really important lessons to be learned. In fact, I'm going to name this episode CZ versus SBF, because CZ got 4 months and he was engaged in some of the worst money laundering, intentional money laundering you can imagine, with terrorist organizations, with criminal enterprises, and a lot of other nefarious folks. Sam Bankman-Fried got 26 years. for basically defrauding hundreds, if not thousands, of investors with his fake securities and fake currency. But the point is not so much the difference in their conduct. I mean, Michael Lewis was going to write this as Darth Vader versus Luke Skywalker until it turned out Sam Bankman-Fried was Darth Vader. But the point was, what do you do when you're caught? What do you do after you find out you've engaged in an FCPA violation? What do you do after you find yourself above the fold on the front page in the New York Times on a Sunday edition for bribery and corruption in Mexico? What you do next really can impact what happens to you when it comes time for fines, penalties, or criminal sentences. And that's what I really want our listeners to think about with this 4-month sentence. I thought the conduct of CZ was absolutely horrendous. But what the judge said was, one, that he turned over leadership of the company in terms of resigning as CEO, still the largest stockholder, but he's not in a leadership role of the company. He's allowed the company to both pay a huge fine, but also have significant U.S. oversight in the form of a monitorship. And this is the one that struck me the most, Kristy. He took responsibility for his actions such that the judge believes if or when he's released, not if, but when he's released in 4 months, he won't re-engage in the same conduct. Now, let's contrast that with Sam Bankman-Fried, who lost billions of other people's monies, defrauding them. But when he went to trial, basically said, I made a bad bet. My bad. I won't do it again at least till I get out. And that's what the judge said. He said, you're not credible on the witness stand. You lied under oath, I think. And I believe when you are released from prison, if you do not serve a long and onerous sentence, you will re-engage in the same or similar conduct. So therefore, I'm going to put you away for a long time so you can't hurt people. And that's a really important lesson for even in our civil world of FCPA enforcement, because the government and now a judge has made clear that they value taking responsibility for your actions. That's been a part of the sentencing guidelines since 1992. And we never talk about that. We never have a podcast on taking responsibility for your actions. You and I don't think I've ever written a blog post on that topic. And we talk about remediation, we talk about self-disclosure, we talk about cooperation, but we don't talk about the real power of taking responsibility for your actions. And that's why I really wanted to talk about this sentence and contrast it with Sam Bankman-Fried, because I think we've had the DOJ send a very clear message. There's a clear message in the sentencing guidelines, and now we have a federal district judge, the court, sending a very clear message that if you take responsibility for your actions, we are going to give you credit for that going forward.
Okay, so this article I thought was so interesting. The federal sentencing guidelines, according to the article, would be 18 months. Prosecutors were pushing for double that. They wanted 3 years. And the and the defense said 0 probation because he is never been in jail before, so no recidivism. And he also basically just didn't have a good enough compliance program. Right? That this is basically the you didn't have a good compliance program case. And the prosecutor said, you got to be freaking kidding me. We have all this evidence that he knew full well, especially with the U.S. sanctions laws, that he was engaging and that there's evidence that he was engaging in money laundering, or he wasn't the argument is he wasn't personally. He knew about it and didn't do anything about it. I can almost, as a lawyer, clearly see arguing either side of that case. And it's really interesting which way the judge came down. And I think you're right about a lot of the theory behind that, but I am surprised that it was quite that low, given the level of knowledge that he clearly had, given what happened in the court case. I'm surprised.
I agree. And frankly, I was shocked. And then I read what the court said, and I thought, as shocked as I may or may not be, there's a real message here. And it's one you and I haven't talked about before. And I don't know anybody's talked about taking responsibility. And that's literally in every DPA or NPA I've ever read, that at some point the nefarious or guilty party takes responsibility, there's real power in that. There's actually a discount for that in the sentencing guidelines as well. A lot there to mull on. The other thing that I cannot understand, Christy, is there was a $4 billion penalty paid by Binance to the U.S. government for the money laundering allegations. CZ voluntarily came back to the United States when that judgment was announced. I can't believe there wasn't a deal for his sentence at that point. I don't know if you've studied medieval history, but there used to be a thing called a safe conduct pass. And under a safe conduct pass, you could go to an enemy's camp and they weren't supposed to arrest you or worse, kill you. He comes to the United States voluntarily and gets arrested. I didn't quite understand how that hadn't been resolved beforehand. I was shocked that he would come here and chance being arrested. I understood why the court didn't release him during pendency because he was certainly a flight risk, and he gets 4 months. Intellectually, it really doesn't make a lot of sense to me, and that's why I tried to pull that one lesson out, Christy, because that's the only reason I can see that the judge said he gave him such a low sentence.
Right. We've covered so much about crypto on here because the article we discussed a few weeks ago that said that one of the trading platforms had more transactions than Visa, right? Over the course of the year. If we're telling people that you can ignore any of the money laundering issues with that, and it's a very low penalty, I think that is an extremely dangerous position to be taking and an extremely dangerous precedent, frankly.
I agree. All we can point to is what the court put in final sentence.
No, I don't think it's going to be the last one of these, so we'll find out as the world keeps turning. But let's move on to somewhat related topic from crypto, which actually is about privacy, right? Because crypto is supposed to be privacy. People are finding themselves paying more attention to privacy. And I mean, by people, I mean individuals. The next article is from our great friend, Matt Kelly, Radical Compliance, and it's called Report Spotlights Privacy Access Requests. So Matt analyzed a report by the company DataGrail that looked at the prevalence and cost of data subject access requests, frequently referred to as DSARs. So DSARs are communications from people, frequently customers or employees, to do something with their personal data. So it's usually something like, please delete my data, please stop selling my data, or tell me exactly what you've got on me so I can see it. Now, I haven't seen a lot of good analysis on the cost of these, so it's really great to finally have some quantification. Um, it turns out more and more folks are making these requests. The study found that numbers of requests have soared 246% in the last 3 years. That's a lot. And each of these requests costs money to fulfill. So the average apparently is if it's a manual process, so you don't have any technology helping you out, the DSARs cost approximately $1,520 each to complete, which is up from $1,400 a few years ago. Now, states like California include consumer rights to this kind of information, as do laws in the EU. The GDPR brought in many of these specific rights, as well as the UK and beyond. So I was surprised to see just how quickly the number of DSARs are going up, specifically in the United States. Personally, I still feel like most people don't understand their rights when it comes to data, but maybe that's changing. How do you see consumer behavior changing, and how quickly do you think these laws are going to keep going?
If we look at GDPR and even more specifically at the EU, excuse me, the UK, these are hugely expensive
Yes, they are.
and they're hugely costly. And our colleague Jonathan Armstrong has tracked these through some various sources. And if you, I mean, if you get 1,000 a month, it takes an hour to do one. Where are you going to come up with 1,000 hours a month? Non-revenue. And the threat of data privacy or data request can get certain actors to move. And so it can be hugely abused. The other flip side is it's data about you. Why shouldn't you be able to get either your data or what they've collected about you? So it's a dynamic tension. I think obviously some states are more liberal in this. In the great state of Texas, you don't have any right to get your data. It can go kind of either way, but it's a huge cost, and businesses are going to yell and scream and cry to the high heavens that we can't afford this. Maybe they should quit keeping people's data.
Yeah, I remember I lived in the UK for nearly 9 years. And one of the best ways, if you were an employment tribunal or you were arguing to try to get a settlement from your former employer, one of the best things you could do is file one of these. And if you made a settlement, it will just go away as part of that. And because the expense, especially on small businesses, they just said, forget it. Let's settle this thing. I don't want to be responding to this. And frequently, of course, you could get some pretty interesting data on how people talk about you for your employment tribunals. I think it's going to be interesting to watch US citizens wake up and go, oh, wait, I have the right to understand all of this stuff about myself. We'll see what happens.
So, Christy, what do you say to the CEO of a company who's got one of the top 10 FCPA enforcement actions ever when he says we're overregulated?
I
Does Spark Consulting have a consulting package for such a company?
Yes, but it's really to help you with the regulation as opposed to argue it shouldn't be there. But I mean, I love this one, Tom, the driving Europe to irrelevance. Please explain why Europe is becoming irrelevant.
The CEO of Ericsson, i.e., $1 billion plus FCPA fine, said Ericsson and other digital companies are angry at regulators in the EU because they're taking such a long period of time to review potential M&A deals. Oops. I guess he forgot that when you do an M&A deal, it's not necessarily in the public interest to have a combination that big. Oh, and at least in the US, we've had laws on the books since 1890 on that point. Overregulation from one of the biggest bribery and corruption violators. I just, something about pots and kettles here that just doesn't seem right to me.
Yeah. So the article, I actively enjoyed it. There's lots of colorful language. It's not just the Ericsson CEO. There's several of the different telecom and digital companies basically arguing that the M&A rules and also the divestments and things that the requirements around them are making Europe a lovely place to go to for cafes and museums and good wine, he mentioned as well, which I appreciated. But then it wouldn't be a place to live anymore because it would be irrelevant. Um, just such a great quote. But I mean, look, I live in California. I know a lot about overregulation. But the fact of the matter is, EU is still the largest trading bloc in the world. California has the world's fifth largest economy, depending on the minute. I really deeply am unconcerned with Europe or California becoming irrelevant. I can't see the regulators responding to this really at all or caring, but do you think that they'll change their tune, Tom?
I also found it interesting that he didn't say this while the DPA was still in effect. The DPA has been concluded. Congratulations, Erickson. You successfully navigated your DPA. And like within a couple of weeks after that, we're overregulated here. So I just, like I said, pots and kettles,
Indeed. All right. Switching gears entirely. Tom, do you think employees want cash bonuses?
all cash all the time.
Yeah. So the answer when I was an employee before I owned my company was an overwhelming yes for me. And I'm guessing for my employees as well. Apparently, we are in the minority. So this article comes from Inc.com and it's great, got this great clickbait title, which is called Why Employee Bonuses Do Not Work and What to Do Instead. So the setup for the article is, in my opinion, a bit suspect. So the author is an entrepreneur who opens with a story about how he was facilitating a discussion about employee engagement and retention with other entrepreneurs in Silicon Valley when he brought up the subject of cash bonuses. So apparently, all of the business owners were in agreement that cash bonuses do not create long-term employee retention or engagement. Although people do tend to, according to the research that he cited, stay for short term, but they don't affect their longer term decisions to stay or not. And apparently, for one reason or another, businesses are paying fewer cash bonuses. So, one study by Gusto, which is a payment platform, showed that at end of year cash bonuses last year in 2023 were down 21% from the previous year. So, he has many ideas about what to do instead. The author says he's a big fan of non monetary incentives like unique experiences or gifts with an individual meaning. He also likes giving bonuses such as flexible working arrangements, child support, or which by child support, I assume he means things like having help with childcare bills and expanded healthcare options for top employees. So I don't know. Maybe it's just me. I hate it. I cringed when I was an employee and the employer wanted to take us on an away day or a big dinner where I got to have small talk with colleagues I never wanted to see outside of work. Personally, I'm much more a take the money and run kind of girl. What's your perspective, Tom?
That's exactly right. And I can just see any number of bosses I've had. Tom, we're gonna take you to dinner. Gonna have a really nice steak and a piece of cake. I know you don't drink, but we'll drink your wine for you. Yeah, this is just inane. I'm thinking about corporate culture a lot. I'm doing a big series on it. I want to destroy culture, treat people like 5-year-olds.
I'm pretty sure if you told them, I can either give you $250 or this dinner, that it's really not very hard to make that decision. But apparently, if you lied to bosses of the world to tell people that they're not getting their cash bonuses in favor of the Disneyland away day, you be you.
Yep. Kristy, the FT had our second FT article, and they had a really interesting article on the whitewashing of corporate investigations. And this is a story that pops up from time to time where a corporation is accused of hiring a firm to basically whitewash their investigation. So, my favorite story around that, of course, comes from my time in Houston when Sharon Watkins sent an email to Ken Lay at Enron, say, please investigate accounting fraud. He immediately hires the company's law firm, Vincent and Elkins, to investigate its work on setting up and guess what they found? Nothing was wrong. I know you're shocked. As I tell people, if you ask me to investigate my own legal work, I can tell you what the answer is now. It was great.
Tom, you didn't bill enough
So
for that. You have
uh,
to do full investigation to come to that conclusion. Go
to
ahead.
come to that conclusion. But they do raise, as light as I've made of that, and Vincent Elkins and Enron, they do bring up a good point, which is how do we know that an investigation has really been thorough? Typically, we don't get the investigation itself. We get some results or some press release of the results, if that. And that really points to a difference between a compliance function who wants transparency and the light of day, as opposed to corporate legal who wants to hide everything because it's not in the company's interest, they think, to put these problems out in the public sphere. I'm not quite sure where this can go unless we have really some concrete examples of sham investigations. We do that from time to time, but my sense is when we do have them, it's not the Christie Grants, it's not the Spark Consultings, it's not the you name the white shoe law firm across the world that really specializes in investigations because they don't do whitewashes and they don't do whitewashes as much as I would like to say it's because of their ethical obligations as lawyers. It's because when they sit across from the regulators, all they have is their credibility. And if they've done a whitewash investigation or a sham investigation and they sit across from a regulator and say, we didn't find anything, and the investigator finds something by hook, nook, or crook, they're going to hold that against that law firm and remember that going forward. So it's in those law firms and those consultants who do investigations to do thorough investigations. So when they make a representation to the regulators, they can back it up with some authority. I know this happens, unfortunately, and when you get caught, it's really bad.
Yeah. I mean, I think that there is a fair amount of trust in the public at large that if a company says we did this big internal investigation and we didn't find anything, that there is some faith in that. But there are definitely breakthrough cases where you say, yeah, that investigation wasn't real or didn't work. And there's a massive conflicts of interest when it's you're judging your own work, like you said. So this, I think, is a perennial problem. And maybe it would require the public to be more mad about it. But I don't think they're paying a lot of attention, which does create a challenge for sure.
So is Florida man with us, Christy?
Of course he is. We need to wrap up this party with a person who is always the guest of honor, which is our Florida man. And this time I'm talking about Florida man Terry Jennings, who ran up to a police car asking for help from a police officer sitting at a stoplight. So Jennings was running away from someone who was chasing him. Why was he being chased down? Probably because he'd been trying to rob the house of the person now running after him. So when the police figured out the perpetrator was the person fleeing, they searched him. And unfortunately for Jennings, the police found multiple items in his pockets he could not explain. They were not explainable because they had been stolen from the car that had been left on lots nearby. And to double down on this pain, a woman approached the police saying she caught Jennings trying to break into her car on her surveillance camera. But since the car was locked, he left. Mr. Jennings was booked into Broward County Jail. And Tom, I think the moral of this story is that Florida man should always remember that if he's caught trying to commit burglary in Florida, it will be by another Florida man. That's enough to scare me off for the next 2 weeks or forever. Thank you for joining us. I'm Kristy Grant Hart.
And I'm Tom Fox.